Hi everyone, what are intellectual property rights? Today I want to discuss what intellectual property rights are and discuss 5 of the main types of IP rights that exist. Let's get started. Intellectual property is a creation of a person's own intellect. That means it's an intangible right granted to a person who creates a work, and this right is granted for a limited period of time. Now, IP rights only protect the expression of an idea and not the idea itself. For example, if you had an idea about writing a book about a boy wizard who went to a wizarding school and vanquished evil, that idea would not be protected by the law. But if you wrote a book called Harry Potter, that book would be protected as an intellectual property. Today I want to focus on 5 main types of intellectual property rights that exist. Those are copyrights, trademarks, patents, industrial designs, and trade secrets. Of course, there are other intellectual property rights such as geographical indications, plant varieties, databases, passing off, etc. However, we won't be discussing those rights in this episode. The first type of IPR I want to talk about is copyrights. Copyrights are a right given to the creator or the author of an original work, which usually covers artistic, literal, and musical works. That is, a copyright will usually protect the author of an original book, the painter of a painting, the lyricist and the music composer of a song, etc. And most importantly, today, even computer softwares are protected as copyrights. The threshold requirement you must satisfy to get a copyright is that your work must be considered original. Usually, this threshold will be met if your work is not copied from somebody else. Now, according to the World Intellectual Property Office, this right granted under a copyright will last for the lifetime of the author and at least 50 years thereafter. However, some countries allow the copyright to last for 70 years after the death of the author. The owner of a copyright will be entitled to 2 types of rights, that is, economic rights and moral rights. Economic rights are the rights to exploit the work financially, and the moral rights are the right to be recognized as the author of the work and to not have the works derogated in any way. The second type of IP I want to talk about is trademarks. Trademarks are usually granted to recognizable signs and designs that are used to identify that certain products and services emanate or originate from a particular source and to distinguish these products and services from the services and products of another. Now, for example, one of the most famous trademarks in the world is Coca-Cola. Now, what the Coca-Cola logo does is that it tells the customer that this product originates from a particular source and it has the same quality that is associated with that brand. Another good example is the Apple logo. Now, it tells the buyer that the phone or the laptop that you're about to buy originates from that company and that you can expect the same standard and quality you expect from that brand in this product. So trademarks are ways for customers to identify goods, and this identification leads the customer to attribute certain goodwill and reputation to that product. The rights associated with trademarks seek to protect this goodwill and reputation that the mark has generated. Trademarks are usually valid for 10 years, and you can renew the trademark at the end of every 10 years. The third IP right I want to talk about is patents. Patents are usually granted to new inventions which have an industrial application. Now, the threshold requirement you need to satisfy to be granted a patent is very high. Usually, you need to show that your patent is novel, that it has an inventive step, and that it has industrial application. The first requirement of novelty means that the invention must be new to the whole world. That is, there must be no identical or similar product invented anywhere else in the world. The second requirement is that there must be an inventive step. That is, there must be an improvement made by the invention to the status quo that is not apparent to a person skilled in the art. And the final requirement is that there must be industrial application, that is, that the product must be capable of being used in an industry in real life. The duration of a patent is usually 20 years. Now, this is obviously much shorter than the protection you get in some other IPs such as copyrights, but of course the protection you get in a patent is much more stronger than the protection you get with regard to a copyright. Patents are a crucial right that drives industry all around the world because it rewards the infusion of millions of dollars into research and development by companies. Right, the fourth type of IPR I want to talk about is industrial designs. Industrial designs are rights granted to a person who comes up with a new and innovative design for a product. Now, these designs are purely cosmetic and are not technical. For example, the Coca-Cola bottle when it first came out would have been quite unique and different from the other types of bottles in the market. So what an industrial design is trying to protect is the look and feel of a design. The threshold requirement to be granted an industrial design is that you must show that there is novelty of that industrial design. That means that the design must be completely new anywhere in the world. The validity period for an industrial design is usually less than other IP rights, and this varies from country to country. But the WIPO recognizes that the protection for an industrial design must at least be for 10 years. The final type of IP right I want to talk about is trade secrets. Now, this right applies to any information that has been kept a secret and has not been disclosed to the public. Where such confidential information is disclosed to a third party, the third party must maintain the confidentiality of that information. Now, if, for example, the third party discloses or breaches or leaks that information, then that would be a violation of the IP right. For example, the Coca-Cola recipe is a tightly kept secret and is probably worth millions of dollars. So anybody to whom that information is disclosed is bound to keep that information secret. Usually when such information is disclosed to a third party, it's a good idea to sign a non-disclosure agreement so that the other party is aware that the information that is being granted to him is confidential information. However, you must understand information that is within the public domain is not protected as confidential information. Anyway, those are 5 of the biggest intellectual property rights that exist. Let me know in the comments if you're interested in learning about the other types of intellectual property rights as well. And consider subscribing to the channel and liking the video if you like this kind of content. I'll see you again in another video. Take care.